everyone, welcome back to This Week in Immigration. I'm Jordan Lapierre. This week, one story from multiple angles. We explore the immigration court system, how it works, and why we should care. All that just ahead. But as always, remember, subscribe, rate, review, and share this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. You can also stream on our website at bipartisanpolicy.org. And while you're there, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. Hi, Theresa.
Hi.
Cris Ramón, Policy Analyst.
Hey,
Cris.
Doing well.
And Tim O'Shea, Immigration Policy Intern. Hi, Tim.
Hi, Jordan.
So, Theresa, let's start with you. Earlier this year, the Department of Justice announced a zero-tolerance policy on illegal entry, which we've talked about here before, which meant that people caught crossing the border illegally would be criminally prosecuted. And that had a lot of secondary consequences, including the family separations we saw happening earlier this summer. And it also essentially created two separate tracks for dealing with those families who crossed together. Can you explain that?
Sure. I think a lot of people maybe were a little bit confused about the idea of criminally prosecuting immigrants, thinking that, well, if they go into removal proceedings, isn't that a prosecution? Isn't that a crime? And the answer is no, it doesn't have to be. Immigration removal proceedings and the immigration courts are not criminal courts. They're not the kinds of courts that you see on Law and Order. They are a civil court, which means they're an administrative court. They are a function of the administrative agencies of the government, not the judiciary. So this decision, what it basically said was, in addition to being subject to administrative immigration removal processes, we have the option to also prosecute you under criminal laws. Now, most immigrants who entered illegally weren't prosecuted under those laws if it was their first time, because it's a misdemeanor. A lot of people would just get time served, maybe a minor sentence, and it didn't have a big impact. But the zero tolerance policy said we are going to actually criminally prosecute everybody who comes across for the first time. And so that meant a lot more people were, if you will, detoured into criminal justice proceedings before a U.S. magistrate judge under the judiciary for prosecution of this crime. And then when they finished with that, they were sent back to the administrative immigration courts to be processed for removal. So you're right. It was basically two different systems addressing the same issue.
So as you described the criminal court system, I think most of us have at least a rough sense of how that process works. But as you said, immigration court is an entirely different animal. And that's really what we want to focus on today, is explaining that system for folks. So let's start with who administers the immigration court system. It exists separate from the traditional court system.
Yes. So as I mentioned, the immigration court system is a function of the executive branch of government. Immigration courts are actually housed within an office of the Department of Justice. It's called the Executive Office for Immigration Review, EOIR. Immigration people call it EOR for short. And that is the office that oversees some 50 immigration courts around the United States. Now, the immigration courts, again, are not judicial courts like you would see in a criminal proceeding. They are still administrative offices. So they're often housed in the same immigration buildings as the immigration offices in those areas. But the purpose of the immigration court is to appeal the administrative actions of deportation and removal from the United States. So the immigration judges themselves are employees of the Department of Justice, and the Attorney General, currently Jeff Sessions, is the overseer of all of the immigration courts. As a matter of fact, the Attorney General has the authority to review and take appeals of any immigration judge's decision, and from time to time refer to himself decisions to review.
And Jeff Sessions has exercised that authority recently in some significant ways. Can you explain what he's done?
So the Attorney General referred to himself a couple of cases, but one very important case related to the qualifications to get asylum in the United States. He asked for these cases to be referred to him, and he issued a new decision that changed the requirements and the standards for who could get asylum in the United States. He overturned some previous immigration court decisions. He overturned decisions of the Board of Immigration Appeals, which is another administrative body that hears appeals of the immigration judges, and set a new standard that is now binding across the entire U.S. government. So the Attorney General has big authority over the immigration courts, and they do not have the kind of independence that you would see, say, in the federal judiciary.
So that's one major difference between immigration courts and traditional court system that we're familiar with. What are some of the other key differences?
Sure. So a few things. If you go into an immigration courtroom in the United States, let's first say who's going to be there. There's the immigration judge. For the government, representing the government in the system is usually an attorney from Immigration and Customs Enforcement's Office of Professional Legal Advisor, or OPLA, OPLA. That person essentially serves as you will, the prosecutor. They represent the government in charging an immigrant with being removable from the United States. Then there's the immigrant themselves, and the immigrant might have an attorney. Now, unlike the criminal system, where if you don't have the ability to hire an attorney, there's a public defender. In other words, the government pays to make sure you're represented in criminal immigration proceedings. In immigration court, you don't have the right to an attorney. You can have one if you can afford one or you can find one. But if you can't afford one, then you may represent yourself. And an awful lot of immigrants do go into court without attorneys. And so those are the main players in the immigration system. There's no jury. The immigration judge is the final arbiter. The immigration judge is the one who decides whether or not somebody stays or goes according to the law. The immigration judge is the one, for example, if you make an asylum claim and say, I don't want to be removed from the United States because I'm afraid of going back and I request asylum, the judge is the one who will decide whether or not you qualify for asylum.
And who are those judges in this system? Are they required to be judges in other courts?
Nope. The qualifications to be an immigration judge in the United States, you have to be a lawyer. You don't necessarily have to be an immigration lawyer, but you do have to be a lawyer, and you do have to be licensed to practice law in a state, so you have to be admitted to the bar somewhere. You must be a U.S. citizen or national, so you can't be, for example, a permanent resident. And they have to have a minimum of 7 years of post-bar admission legal experience. And again, that legal experience doesn't necessarily have to be in immigration. Some of the things that could qualify, if you have substantial litigation experience, in other words, you've litigated lots of different cases, or have experience handling complex legal issues, administrative hearings, such as in Social Security hearings or other sorts of cases, and general knowledge of judicial practices and procedures, that can be enough to get hired. An awful lot of immigration judges do have an immigration background. Some of them come from immigrant serving agencies. Some of them come from the government. Attorneys who have been part of ICE OPLA often apply to be immigration judges. And then there are immigration judges who come from elsewhere and have not necessarily immigration legal background.
So you mentioned the lack of a right to guaranteed legal representation in immigration court. Do immigrants have some of the other rights that we traditionally associate with court proceedings? I'm thinking, for example, of a presumption of innocence or the burden of proof being on the government rather than on the immigrant.
It's exactly the opposite in immigration court. In immigration court, the burden is usually almost always on the immigrant to prove that they deserve to stay in the United States. The government has a very easy case to prove most of the time that someone's removable, particularly if they were apprehended coming in between the ports of entry. That in and of itself renders you removable. But then it's the burdens on the applicant, the immigrant, to say, yes, I might be removable, but please don't remove me. I'm eligible for these types of what they call relief from removal. Asylum may be one of them. You may be eligible for relief under our obligations in the Convention Against Torture. There may be other reasons why you can apply for relief, withholding of removal or something like that. The judge has some discretion to offer other means of relief, but in general, there are qualifications for each of those. And it's up to the immigrant. If the immigrant does not sustain their burden of proof in proving that they're entitled to stay under one of these things, then they may not be given that. So unlike criminal court, where there's a presumption of innocence, in immigration court, usually the presumption is you're removable from the United States. Prove to us why you shouldn't be.
So, Cris, this is where I want to bring you in then to talk me through the removal process for folks who do appear before an immigration judge and get that decision that they should be removed.
So the whole process begins with a notice to appear. This explains why DHS believes an individual should be removed from the United States, the time and place of the hearing, and the consequences of failing to appear. So every individual will get that. And usually there might be an additional step, which is a bond hearing in what they call a respondent. So the non-citizen in these proceedings are called the respondent. The respondent Sometimes they might have the opportunity to be released on bond, but in this hearing, the immigration judge will consider whether they're a national security risk, risk of flight, or they might have abscond from this whole process. Now, the first step in the formal proceedings is what we call the master calendar hearing. This is sort of where the respondent has a chance to plead to the charges in the notice to appear. They can also submit applications for relief from removal and request a merits hearing. These are pretty quick, probably no more than 15 minutes. And it can actually be multiple respondents who are kind of being put through this whole process, at multiple people appearing in the room before the immigration judge. An individual can admit to the allegations and say, concede to the charges, and then they can be put through the removal process. But if they decide to actually contest the charges, then we get moved to a merits hearing. And that's sort of the formal individual hearing where the government presents evidence, the respondent can present their evidence, they can make the legal cases for removal, and this is where they'll be discussing the law and its application to this case. The immigration judge will make a decision, and that's what happens. It is worth noting that although Theresa is saying that the burden of proof is largely on the immigrant, those are individuals who are considered inadmissible. Those are people who tried to enter the United States and weren't allowed in. The burden of proof shifts if you're deportable. Deportable is if you were admitted to the United States and then the government says, okay, we're actually going to remove you. And this actually can include green card holders, which a lot of people don't realize. Then the burden of proof is on the government. So there is a little nuance to that whole process. But at the end of the day, the immigration judge is going to hear everything and go, you're in, you're out. There's two more things to consider. An immigration judge can actually issue an in absentia order, which is if the individual doesn't show up to any of the hearings, that then the judge can say, I'm issuing an order, you're to be removed. And there's some pretty severe repercussions with this. And of course, you can appeal decisions. You can appeal to the court, or you can appeal directly to the BIA, which Theresa was mentioning earlier, and that can sort of can generate a whole host of issues because those can actually establish precedent for the application of these laws. So that's basically the whole process. It's pretty straightforward, but it can take a long time.
Yeah, exactly. How long does this take on average?
So we've been writing about the court backlog for a very long time here at BPC. It's one of our regular features. I feel like we always have something to say about this, but the average wait for that merits hearing can be about 2 years. That's a really long time. I mean, it's yeah.
And in that intervening 2-year period, either folks are released on bond or they're in some sort of detention.
Yeah, and I think that this is sort of one of those things where you've been hearing the Trump administration talk about catch and release. Mm-hmm. One of the things that they've been complaining about is, we detain these individuals, we let them out for a couple of years before the immigration court hearings, and then they disappear. So they can be released, quote unquote released, and that's sort of one of those things you've been hearing them talk about.
Or I should mention also alternatives to detention being another option that's sometimes used.
Absolutely. I mean, there's some forms like ankle bracelets. But there's also some community-driven programs where the respondent, the non-citizen, will be checking in with the caseworker to sort of ensure that they're sort of following the procedures as well.
So broadening out a little bit, how healthy is this system overall? Like you talk about it taking 2 years to get through this process. That seems like a really long time. Do we consider that to be good, not so good?
Oh, this is really problematic. I mean, there's no other way of putting this other than this is really problematic because...
What's so important about this?
Well, the thing is, Theresa and I released an op-ed a couple weeks ago talking about the implications of this. And it's basically two things. A, it undermines the immigration enforcement system, and it also undermines the humanitarian system that we have here in the United States. If you can't process individuals quickly enough, so they get put through the system, they appear before an immigration judge, and they get removed really quickly, people are going to realize, hey, coming into the United States or attempting to do that, you're going to get removed really quickly. And you know what? We might not actually try to do that. The problem is if you have these extended wait times, it's likely that some individuals might think, you know what, let's take a chance, we'll see what happens, and if not, I'll be released. Which, once again, the administration's been saying this is catch and release. I think people have different perspectives on that, but there are some issues with individuals showing up to their court hearings.
The flip side of that, just to add in, is if somebody has a credible asylum claim, after 2 years, documents may go missing, witnesses may not be able to appear, they may have a hard time tracking down more details. Sometimes time can give them time to put together a case, but other times it can be to the detriment of the case. So if you have people who actually do qualify, it actually behooves the process overall to have them have a fairly rapid hearing as well. And 2 years is an awful long time.
Well, sure, and I'm sure that for some of those folks who are in fear of a certain situation, that situation could have changed dramatically over the course of 2 years.
Yeah, it may have. And government policies can change over those 2 years. If somebody applied for asylum as a relief from removal a year ago, the decision that the Attorney General just issued would probably have a significant impact on their case and how it's going to be decided now before an immigration judge. Whereas if the case was processed earlier, that might be a different outcome. So lengthy timeframes. There's a reason that in our Constitution for criminal justice, we ask for a speedy trial. The immigration process doesn't have that requirement, and we're seeing the implications of that.
So if this backlog is so important and has such severe negative effects on immigration enforcement, and you mentioned humanitarian efforts, Cris, why did we let it become so large? Why was nobody sounding the alarm on this?
So I think the key thing is that this is sort of one of those things where the frog is in the pot and you're turning up the heat. And I think the analog is basically because we don't have enough immigration judges, to be honest. I mean, yes, you had other factors like, the Obama administration's effort to deport more undocumented immigrants, increases in unaccompanied minors coming to the United States from Central America, the Trump administration boosting its enforcement. But the bottleneck has also been the lack of immigration judges. In the op-ed, we were saying there's 321 immigration judges. They do about 678 cases every year. Well, sounds great, but they actually get 1,900 new cases every year. So they're barely being able to tackle all these things. And I think Theresa and I have heard horror stories about judges having multiple dockets. They have clerks who are working for 5 judges and they're running around. It's
And the other thing about the immigration judges, I mean, if you go on USA Jobs and look at an immigration judge job description, one of the things you will notice is that they're expected to travel at least 50% of the time. Judges ride on circuits.
Wow.
And so they can be sent down to the border. The Justice Department under Jeff Sessions sent a lot of immigration judges down to the border to process cases. So it's a hard job. It's a very hard job. And they've been trying to recruit. They did get authorization last year, I think, to hire 75 more immigration judges. They're trying to recruit, but it's hard, 1, to find the right people, 2, who are willing to do this, and 3, that they can get them on board on time. And going back to what Cris said about the frog in the pot, the other disconnect is that over the last 10 years, we have significantly beefed up the resources to apprehend undocumented immigrants, both inside the country and at the border. Even though overall levels are down, the ones that are arriving are more likely to be people who would have to go before an immigration judge. So we have seen a shift towards on that front end, but there hasn't been a commensurate increase in resources on essentially the back end of the process. So you have this huge funnel going into a really tight bottleneck of immigration courts, and they're just getting swamped.
Tim, this is where I'll bring you in. The Trump administration and members of Congress have proposed some different steps to try to reduce this backlog. And you wrote a post recently on our blog that explored some of those. So tell me about a few of those ideas.
Thanks, Jordan. So the current strategy deployed by the Department of Justice has been a small increase in the number of immigration judges, as well as setting a case quota so that each immigration judge will be expected to complete about 700 cases per year. As Cris said, the current average amount of completed cases per year for an immigration judge is around 678, so that isn't that drastic of a change. Comparatively, there have been 2 recent bills that have sought to address the problem, but both of those focused on adding more judges into the immigration courts. The USA Act, proposed by Republican Representative Will Hurd and Democratic Representative Pete Aguilar, would have added 165 new immigration judges over 3 years. This was just one piece of the bill, which also included other immigration reform measures, including relief for immigrants under DACA and funding for border security technology. But the second bill to address the backlog was the Protect Kids and Parents Act, which was written by Republican Senator Ted Cruz. That bill would have added 375 immigration judges to the courts, along with another measure that would require asylum cases to be adjudicated within 2 weeks. Senator Cruz's bill also sought to put limits on when immigrant families could be separated. Neither of those bills have gone up for a vote. Many are also skeptical about whether or not President Trump would approve of those measures because he has historically spoken against the idea of hiring more immigration judges because he's skeptical about their interpretations of the law in some cases.
That's obviously an important point, but putting that aside, you've also looked at whether either of these ideas would make a significant impact. What did you find?
In terms of clearing the backlog, Senator Cruz's bill would have been the most efficient, mainly because it would just add way more judges than any other present option. The current DOJ initiative barely put a dent in the backlog, suggesting the case quota idea is not a substitute for other needed capacity changes.
So the other thing that I thought was really interesting about the blog post that you wrote was that you found there was a point in time at which, had we intervened, we could have reversed this tide or at least sort of slowed things down. What did you find?
So Theresa posed the question about whether or not a hypothetical, I think you called it a reserve corps, of immigration judges could have averted the creation of this giant backlog. So what we essentially ran in the numbers was back in 2014, when the backlog really started to pile up, when there were a lot more asylum seekers entering the United States, we examined what the effect might have been if 100 immigration judges had been deployed at that time when it appeared that way more cases were going to be entering the system. And in fact, we found that could have essentially stopped the growth of the backlog, at least up until the present day, had we deployed those 100 judges. And even though that looked to the past, we still took it as a lesson. At the end of the day, you just need more people and more capacity in the courts, period. You'd be hard-pressed to find another way to work through a backlog of this size.
Theresa, is there any way around this hurdle, or is this really the thing that we have to solve?
Well, I mean, if you, as Tim said, the president is skeptical of the immigration courts, and he wants to just be able to summarily remove people from the United States completely. I think there are a lot of folks who say that we have created the immigration system the way it is, in part because we want it to be fair as well as conduct effective enforcement. We do have requirements under our law, and we are signatories to international law that require us to accept and adjudicate claims of asylum. So I think there's a real need to have a system that actually functions here. And yes, you can look at other things. I know the administration is trying to figure out how to put more people into quote unquote administrative removal processes that don't require going to a court. But if somebody's applying for asylum, that's going to require the court system. And I think the reason I posed a question about a reserve corps is one of the things that we have historically seen in the United States and elsewhere is that we don't build our immigration systems to address changes in immigration flows that put stresses on our system. We don't have a reserve. We don't have an emergency surge capacity. And so when these things happen, we respond almost too little too late, or we tend to respond with very harsh extreme measures as a way of deterrent, which don't always work and sometimes backfire, such as the zero tolerance policy, which is now being adjudicated in the courts. So I think it's something to think about on a bigger picture level, not just in our current situation, but looking forward for the United States. We need to think about whether or not we should create this kind of capacity within our immigration system to deal with these kind of unexpected events, which they're unexpected, but they're not, because they've happened periodically throughout our history, where there have been just arrivals of migrant groups that we hadn't expected and that we're having to deal with.
Yeah. I mean, 2 points on that, too. I mean, the thing is that's not just limited to the United States. You had the European refugee crisis where the EU kind of fell asleep at the wheel and they started seeing the signs of these folks coming in and really didn't respond to the crises until 2015, 2016. So it's really a question of how effectively can you manage responses to immigrant flows? I mean, I think that this is a common problem, but I think coming back to the US, it's also talking about basic infrastructure investments. I think, Theresa said the immigration court system doesn't have an electronic filing system. Theresa and I are both former paralegals who have worked in civil law, and the fact that we can't access an electronic filing system brings fear to our hearts. But these are basic things that, I mean, this is almost as analogous as using Netscape when you have Chrome.
Yeah, they're way behind the times, and that does impact their ability to be rapidly adjusting, right? You're asked to complete more cases, but you're still doing it in a paper-based system. If somebody moves from one immigration court to another immigration court, for example, a case gets shifted because maybe somebody in detention has moved to another detention center, it can take months for that transfer to happen because the literal paper file has to go from one court to another court and be accepted by that court and entered into their system and their dockets. So that's the system we're dealing with. Yeah.
The immigration court system is the AOL-CD of the administrative court system.
Administrative court system
in the United States.
Yep.
And unfortunately, it doesn't come with 1,000 free hours.
No, it does not.
Cris, Tim, Theresa, thank you all for being on the program this week. And thanks to our producer, Emily Schrader, and especially to you all for listening. Please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. Just search Bipartisan Policy Center. Join us again next time on This Week in Immigration.